Do you think lobbying is a bad thing?
Well, as a judge, I don't participate in ex parte contacts. I think the commissioners have a different role. They're political appointees, and so it's up to the legislature to determine whether there should be different rules that apply to commissioners.
But do you think that lobbying contributes to bad decisions on behalf of the CPUC?
Not necessarily. I mean, there are pluses and minuses of lobbying. That provides information to commissioners, and it provides access to commissioners. In my mind, if the rules are followed, in some cases, of course, they have not been followed, but if the rules are followed and everybody does have a chance for equal access, the rules seem reasonable at this time. Of course, there could be changes.
If the rules are followed, if information is disclosed, if commissioners are able to balance, the good and the bad and come up with good decisions, lobbying could potentially be a good thing in terms of helping inform them. That's why it can be bad, it can be good, but banning it altogether, are we setting the commissioners up to make bad decisions?
Commissioners need to make decisions based on essentially two different types of information. One is the record in the proceeding. All decisions must be based strictly on the record, so that if somebody lobbies and comes in and says, hey, here's some other information that you need to consider, that really should not be part of the decision-making process. In my experience as an advisor—
Even if it's disclosed?
Well, legally, it can't be part of the decision itself. It can't be the basis for the decision.
So why don't we ban it altogether?
Well, in my experience, when I was an advisor to a commissioner, much of the lobbying was essentially talking about the record itself, so that the commissioner would receive further information about, what a witness said, what arguments were made on the record by a party, how the judge weighed the evidence, and a party might ask a commissioner to weigh the evidence in a different manner. That would also be within the record.
Okay, maybe we'll ask out of our next panel if they see as lobbying as something we should even ban. And maybe as they come up, thank you. We'll ask for our next panel. Mr. McGuire?
I apologize, Mr. Chair. Just one quick question. If
Sure,
that's,
sure.
I appreciate, Mr. Chair, and thank you for bringing us together, sir, and thank you for your time. And I just want to touch base on changing of law and rules. So if it's internally, looking at some homegrown rules that are being brought forward by both PUC consultant as well as executive staff. And I think the incredible work that Senator Hill and Senator Leno are doing this year. I guess I want to touch on, we can change every law that we need to, but then you have that culture of coziness that has taken hold. So how do you see, in all your time at the PUC, be able to change the culture internally to ensure that there is equal access for all when it comes to all the different proceedings and hearings that you're bringing forward?
Right. I have provided personally training to executive staff, to Energy Division staff, to others within the Commission on our rules of ex parte. Actually did about an hour and a half long training for each of them, much more extensive than what I've brought here today. And I have tried, along with other judges, to educate on the rules and to educate the importance of following the rules and to educate the consequences of not following the rules. I know the executive director is looking at certain personnel matters for commission employees who have perhaps violated certain rules or ethics. I know that we have a report coming out from Michael Stromwasser, our consultant, about changes to the rules. So I think that culture change is important. As a judge, and speaking for the administrative law judges, we're very dismayed about the cozy relationships. We're having efforts to change the culture within, and I think that's an extremely important effort.
And I just, one quick follow-up, Mr. Chair.
On the current rules. On the current ruls, because we're going to have people talk about potential changes, and we can have a good discussion about that. Thank you. Thank you, Mr. Gamson. We'll ask for our next panel to come forward. Deborah Bells, Stephen Weissman, and Ed Howard. And we can begin with Ms. Bells. She's Associate Professor of Law at Golden Gate University. Thank you for being here. Thank you for your participation. If you can begin when you're ready. We have a presentation.
Thank you, Mr. Chairman, Senators. Good morning. My name is Deborah Bayless. I'm an associate professor at Golden Gate University School of Law, where I've taught since 2008. And in that capacity, I've written several articles on energy policy. I'm here today with Professor Wiseman to present our study and analysis that we conducted of the CPUC's current ex parte rules and practice. To begin with, we'll provide just a general information about what our study was based on, and an overview of our findings and recommendations, and then open it up to questions. Our study was based on 4 things. First, our legal interpretation of the statutes and regulations related to the CPUC's current ex parte rules. Second, a comparative analysis of the CPUC's rules to similar entities, similar federal entities, state entities, and other states. Third, interviews with other regulators, discussing their experience with other entities. And fourth, our own experience with the CPUC. In my role as associate professor, I'm also a staff attorney at a law clinic at the law school, where I've practiced in front of the CPUC since 2009. And as Professor Wiseman will describe, he was employed by the CPUC for several decades in various roles. We won't provide an overview of what the CPUC's current rules are, because ALJ Ganson just provided that. But to start with, I'll provide a general overview of the purpose of ex parte rules and prohibitions, because that informed our analysis and provided a framework for our recommendation. The general purpose of ex parte prohibition is to prevent parties from gaining an unfair advantage. Parties gain an unfair advantage because ex parte contacts can generally not be rebutted in the adversarial process. This is particularly problematic in contested proceedings, where there are contested issues of fact, because these facts, if they're introduced only in an ex parte contact, are not subject to cross-examination, are not subject to the judicial protections that the CPUC currently has for its proceedings. In addition, ex parte contacts can interfere with the decision maker's ability to make a fair and impartial decision. This can damage the integrity of the process. The Ninth Circuit has stated that ex parte contacts can essentially nullify the public's right to participate in hearings, because after participating in hearings, there's a possibility that decision makers will make their entire decision based on ex parte contacts and not the contents of the record. Now I'm going to turn it over to Professor Wiseman to describe his experience with the CPUC and the major findings of our report.
Senators, thanks for inviting us here to speak with you today. I have been teaching energy law and also directing an energy policy research program at the University of California, Berkeley Law School for about 10 years. Prior to that, I did spend several decades at the California Public Utilities Commission. Being able to say that still shocks me, actually, but I was in various roles. I was a staff attorney for a few years. I was an administrative law judge for about half the time that I was there. I also was a policy advisor to 3 separate commissioners. I think in this conversation, which is really being prompted by recent events, I think it's easy to lose track of the fact that the California Public Utilities Commission is an absolutely remarkable agency. It's got a very large staff of exceptionally bright, very dedicated staff and commissioners. And it was a very hard place to leave over those several decades, because it always appeared to be tackling issues on the cutting edge. And that's the good news. But it's true with all of us individually, and certainly with this particular agency. There's vast room for improvement. And the findings that we're going to offer now are really part of our effort to promote that level of improvement. First, in terms of the way the Public Utilities Commission does its business, its practices reflect a cultural divide between that commission and
most similar agencies within the state of California, on the federal level, and in other states. California, the California Energy Commission and the Air Resources Board are subject to the California Administrative Procedures Act. And under that act, they have a prohibition on ex parte communications in contested proceedings where hearings are held. On the federal level, the Federal Energy Regulatory Commission, which is really the closest, I think, parallel to the California PUC in terms of economic regulation, also has a ban on communications in contested proceedings. In terms of looking at the other 49 states, of the total 50 states, 36 have ex parte bans that apply to contested proceedings. Only 2 states out of the total of 50 fail to prohibit ex parte communications, and one of those is Oregon, which officially in its statute discourages ex parte communications. In all but the most basic complaint proceedings, the California Commission does not even discourage ex parte contacts. To the contrary, it welcomes them. The second finding is that the PUC's ex parte practice is inconsistent with the quasi-judicial nature of most major proceedings. There's a lot of talk about complaint proceedings versus applications versus rulemakings. All of these proceedings have some nature of formal process. In each instance, when the commission initiates a proceeding or a party does, this has to be formally filed and noticed. There's a formal record containing any factual evidence and formal pleadings such as briefs and affidavits and comments. Interested parties can't just go ahead and file a brief or offer evidence whenever they feel like it. They have to follow a formal schedule that's adopted by the commission, or they have to receive formal permission from a presiding officer to present any new information officer. Decisions must be made solely on the basis of information in the formal record, as David Gampson indicated. And that record has to be submitted in full to any court that's going to be reviewing a decision that's issued by the commission. Now, despite all of this, in all of the enforcement, in all but the enforcement proceedings, any party can send off an email to a commissioner or other decision maker, or mail a letter, or drop off a thick document whenever it feels the urge. All that's required is that that information be provided on the same day to all the parties in the proceeding. Despite all the legal protections that otherwise apply, any party to a multi-billion-dollar rate proceeding can call up a commissioner and ask for an opportunity to sit down and chat, or bump into a decision maker in the hallway, or attend an industry soiree and talk about any aspect of the case it wants to. The rules allow it, as long as the first meeting in a series is announced 3 days in advance. The formal rules are all about protecting the rights and pocketbooks of interested parties. They're about promoting fairness and ensuring a right to test the facts that are offered by others. Ex parte meetings are all about getting around these protections and gaining the advantage of unmonitored communication. Now, there's several myths that dominate the conversation when people try to explain why all of this makes sense. First myth, regulators can't make good decisions without private conversations. Now, we had not undertaken a broad survey, but we did pose that question to 3 prominent former regulators. One was John Wellinghoff, the most recent past chair of the Federal Energy Regulatory Commission. Another was Peter Bradford, who was a nuclear regulatory commissioner, and he also at various times was the chair of both the New York Commission and the Maine Commission. We also talked to Marty Cohen, who's the past chair of the Illinois Commission. All strongly objected to the suggestion that they could make anything less than a high-quality decision because of the fact that they don't entertain private communications. None of those 3 commissioners presided in an environment where they allowed for private communications on substantive matters and contested proceedings. And if it was true that you couldn't make decisions without those private meetings, that means that 36 states in the Federal Energy Regulatory Commission make terrible regulatory decisions all the time. That's something that other people are going to have to judge, but it doesn't make a whole lot of sense. Second myth, decision makers can have those private communications and still confine their decisions to the information in the formal record of the proceeding. You heard Judge Gampson trying to explain the situation where the decision has to be based solely on information that's in the formal record, and yet the communication that occurs when somebody lobbies on an individual point is not part of the formal record. That doesn't make any logical sense. Why have the meeting at all if you can't take anything beyond what's in the evidentiary record? Now, Judge Gampson also indicated that an aspiration would be that when someone comes to the office, they're going to point out things that are in the evidentiary record. Well, and the commissioner or the other decision maker can consider those things. That process is available in briefs and oral arguments. There are other ways to point out important facts or important legal issues to decision makers. The dilemma is that a decision maker that's not otherwise familiar with the record has no way to decipher whether a particular claim that's being made in an ex parte meeting actually is something that was drawn precisely out of the record. He or she also doesn't have a way to know whether there was some countervailing fact that might be important to know when trying to resolve a particular issue. And also, from my experience, I think I've observed that often the people coming in on behalf of a party are not familiar enough with the record to understand whether the assertions they're making are actually from the factual record. Third myth, decision makers don't have the time or ability to become familiar with the record in the proceedings that are important to them. The first time I worked for a commissioner, there was only one policy advisor in the commissioner's office. She did not entertain ex parte communications, even though this occurred before the formal rules were created in 1996. When we had a proceeding that was of importance to us, we tried to identify that in advance, excuse me, and then start the process of becoming familiar with that record, reading the pleadings. Occasionally, the commissioner would attend a hearing to hear a critical witness or attend an oral argument. We could rely on the technical staff that was available to help with the decision-making process. That's what happened when there was one advisor. Now, every commissioner has 4 professional advisors, except for the president, and the president has 5. Now, if
Can you define advisor as you present that?
certainly, an advisor would be either an attorney or somebody with some other technical expertise who's assigned to the specific commissioner's staff. We'll have an office right near the commissioner's office, and we'll be devoting full time, thank you, to advising the commissioner on the decision-making process. So what happens is that in some of the offices, in many of the offices, all of the advisors and the commissioner wind up very heavily packing their schedules with either in-office meetings or attending functions outside of the commission, and it becomes a major challenge to be able to set aside the time necessary to look at the record. This is a generalization. Obviously, there are people in various offices who function differently. But you can imagine if you were able to actually free up the time of all of these knowledgeable professionals and rely on the technical divisions that are there specifically to advise the decision makers in their process of coming to a conclusion. You can imagine that there could be a lot of time available for understanding the record and the proceedings that are important to you. The next finding, the PUC's ex parte approach is not well suited for a major economic regulatory agency and for an agency with a high level of independence. Economic regulation is a critical function in the state of California or anywhere else in the country. It affects everybody, and it, by its nature, tends to be the type of decision-making that's most prone to a perception of bias because of the way that we're all affected by economic factors. This particular agency has extraordinary independence. And later in the questions, if you like, we could explore that a little further. But there's a general lack of checks and balances. None of the checks and balances, hardly any of the checks and balances that would normally apply to you as voting members of the state Senate. There is virtually no court review of PUC decisions, and I can go over the statistics with you later if you like. Sunshine is the only protection against unreasonable or ill-advised exercises of power by the Public Utilities Commission. Next finding. The PUC's rules and practices create confusion about prohibited communications and reporting requirements. It's unclear to, obviously, based on emails we've seen on other things, it's unclear to many people as to what's truly substantive communication, what is a procedural communication. It's unclear when somebody has crossed the line in terms of offering a substantive communication and therefore needs to file a report. And it's unclear what makes for an adequate notice of a contact that has already occurred. And the final finding for now is that the current statutes and rules leave commissioners and other decision makers largely unaccountable for their involvement in ex parte communications. And this, we believe, is a very important finding. Although there's a very broad statutory provision that states that ex parte communications are prohibited in certain circumstances, the California statutory scheme does not point specifically to the decision makers and say that they are prohibited from having ex parte communications. We would argue that nonetheless the prohibition does apply to decision makers, and I don't think they would necessarily disagree. But many states directly place the commissioners in the line of accountability and the other decision makers. The statute places the reporting requirement only on the parties. The commission prohibits the parties, forbids the parties from reporting on anything that a decision maker says in a meeting. And so you could see where this can radically change anybody's understanding of what the communication was that took place in a particular meeting, and this is a major problem. We feel that this lack of a direct accountability on the part of the decision makers is a major contributing factor to the apparent repeated violations of the existing ex parte rules. Well, those are our major findings, and I think we'd now like to briefly describe some of our recommendations based on those findings.
Our first recommendation is that ex parte contacts should be prohibited in all contested proceedings, all adjudication and rate-setting matters, and in rulemaking proceedings that are contested and rely on critical factual assumptions. These are proceedings that rely on the determination of contested facts, apply to specific entities, such as rate-making proceedings applying to utilities. The reason for this recommendation is severalfold. First, as you can see by the slide, the CPUC is in the minority of all the entities that we examined by allowing contacts in contested proceedings, currently allowing contacts in, for example, rate-making proceedings. The majority of entities that we analyzed in our report do not allow these contacts. The only other entity that does allow contacts in contested proceedings is the New York Public Service Commission. And it's notable that that commission, the mayor, or the governor, there was an independent commission called the Moreland Commission from the state of New York that's recommended that that broad allowance of ex parte contacts be eliminated because it undermines the indispensable fairness and unbiased attributes of decision makers.
Our next two recommendations stem from this comment I just made a moment ago about the lack of direct accountability by decision makers for compliance with the rules. And there are two recommendations here. First would be that the prohibition on ex parte communications should be directly imposed on the decision makers. The statute, the rules ought to directly say that no decision maker shall, and talk about what prohibited ex parte communications apply. We believe that decision makers will want to adhere to their obligations if they understand their obligations clearly, and that the level of compliance ought to improve significantly. The second part of this is that we recommend that decision makers be given an affirmative duty to report the communications themselves. This is how things are done in most jurisdictions that address the issue of filing reports. Many jurisdictions assume, since some communications are forbidden, that none will occur. Others anticipate if they do occur anyway, that somebody needs to report on it. So in Florida, in Illinois, and California agencies that are subject to the Administrative Procedures Act, and at the Federal Energy Regulatory Commission, all of these impose on the decision maker the obligation to file the report. And we recommend that in California as well.
We also recommend, as Professor Weisman mentioned earlier in his remarks, that the distinction between procedural and substantive communications be more clearly defined. There has been confusion about where this line should be drawn. The California Administrative Procedure Act provides more direction. Specifically, the California Administrative Procedure Act provides that only matters that are non-controversial matters of practice and procedure should fit within the procedure category and be allowed. The examples that it gives are format of the pleadings, number of copies required, and manner of service. So providing this type of direction would help clarify where that line between procedure and substantive should be drawn. In addition, we recommend that procedural communications only be made to the administrative law judge. The administrative law judge, as ALJ Gamson described, for the majority of proceedings is the presiding officer, is the officer that is charged with making the procedural determinations for the proceeding. So this would both be a practical designation, and in addition, it would further protect there from being substantive communications if the line is not correctly drawn between substance and procedure.
Our second to last recommendation is that the definition of a decision maker should include not only commissioners and the commissioners in office advisors, but should include also staff within industry divisions that are advising decision makers on a particular case. Should include the executive director and the chief and assistant chief ALJs, as well as, of course, as the assigned ALJ. All of these people are involved in shaping the outcome of commission proceedings. All could have been, could have had their advice tainted by a private communication with somebody with interest in the proceeding. And some might be pressured or encouraged to carry messages from a party to another identified decision maker. All of these participants ought to be included in this process. Now, there are people in the technical divisions that are going to have to be in contact with the utility in a rate case, for instance, when there's a need to devise a rate table or a revenue requirement table. There's going to have to be an exception for that type of person. But generally speaking, we'd recommend that that the definition include all of these people.
And the last major recommendation that we're presenting, and there's additional recommendations in our report, is that the rules should cover all non-public substantive communications. Currently, the ex parte rules only apply to interested parties. The CPUC's definition of interested parties is narrower than the California APA's Administrative Procedures Act definition. Under the California Administrative Procedure Act, the definition of an interested party relies on the Federal Administrative Procedure Act definition, which is broad, which applies to generally any person that has an interest above that of the general public. The reason to provide this broader definition is first because there has been confusion about who qualifies as an interested person, so it would provide clarity. In addition, it would provide greater transparency, and it would also prevent there from being the potential to circumvent the rule by sending in someone to have an ex parte contact who might not potentially fall within the interested person definition. So thank you for your time. At this point, we'll open it up to questions.